My niece did some school there. Alright, I printed out all my stuff. Really? It's cold in here.
Once you're there, you don't want to come back.
Mm.
Socializing over there. Now, let me know what's that. All rise. Say a pledge to the flag, Mr. Maganon, if you would lead us.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Evening. Thank you for coming. Madam Secretary, have we been properly noticed through the sunshine laws?
Yes, Chairman, we have.
I don't know, I don't think so. We have a roll call?
Mr. Bello? Mr. Hakevich?
Here.
Mr. Davis?
Here.
Ms. Lee? Here. Councilman Lembo?
Here.
Mr. McEnone?
Present.
Ms. O'Leary?
Here.
Mr. Volosik?
Here.
Ms. Matilla? Chairman Ty?
Here.
Mr. Rogoff?
Here.
Mr. Cornell?
Here.
Mr. Leocavello?
Here.
We have a quorum?
All business, new business, administrative matters, do we have any?
Yes, we do. We will be discussing and consider the adoption of the amended housing element and fair share plan.
Okay. All right,
I think we have Mr. Trey Hire Cool Associates to give us synopsis. Let's just, for the record, sir, you want to raise your right hand? Swear testimony about the board in this matter is the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Just for the record, before we have any discussion about amended housing element fair share plan. Sorry? Okay. Before we have any discussion about the amended housing element fair share plan, I'd like to just confirm that your firm is the author of this report dated March 2018. Is that correct?
That's correct.
And there's an amendment. Is that the most recent amendment?
The amendment is through June 18th.
Through June 18th. You're the author of, your firm is the author of those two reports?
That's correct.
All right, then I'm going to move these two reports into evidence, make them a part of the record. They are substantial reports, obviously hundreds of pages long. So what I would ask you, Mr. Hire, is to provide the board and the public with a synopsis of the criteria used in connection with the preparation of your report, which is now part of the record, and to give us the synopsis of your conclusions contained in that report.
Okay, there are 4 items on the agenda tonight. They all relate to your fair share plan. The fair share plan is the document through which communities meet their constitutional obligation to provide for affordable housing. The first item is an amended housing plan element and fair share plan. The housing plan element is part of your master plan. As the borough's planning board, it's your responsibility to adopt and to revise the housing plan. The fair share plan, which is designed to effectuate the housing plan element, is ordinance form, and that is a function of the governing body. In addition to a revised housing plan element, there are 2 ordinance revisions and 1 revision to a redevelopment plan. All of these items are designed to effectuate the executed settlement agreement that settles the town's affordable housing obligation. This board adopted a draft of a housing plan element back in March, and it's a fairly substantial document. The principal differences between the version that was adopted in March and the current version are a significant reduction in the total number of units that it's going to take to address your obligation. The overall number of units to address your obligation is reduced by more than 250 dwelling units. That's a combination of market units and affordable units. You're still meeting your target number of 785 units in the borough, but you're doing it in a manner which candidly has a great deal less impact on the community than the initial version of the plan. So the main differences in the plan are a reduction in the number of units on the national lead site. The number of market units is going from 163 to 132 units. The number of affordable units on that site is going to decrease from 25 to 7. And the two K-land sites, the Kaplan sites in combination, are being reduced from 473 market units to 318 market units, and from 71 affordable units down to 20 affordable units. Again, the initial version of the plan had more dwelling units, both market and affordable, than were necessary to satisfy the plan, to satisfy your requirement. The second item on the agenda is the ordinance. There's an ordinance numbered 413-18. Essentially what this ordinance does is it adopts or recommends zoning for the Kaplan sites, the Camelot 1 and 2 sites. And again, what's happening in this version of the plan is the number of market units is being significantly reduced, and the number of affordable units is being reduced as well. Ordinance number 414-18 deals with the zoning for the national lead site. Again, that number of dwelling units is being reduced significantly, and the number of affordable housing units are being reduced over the initially adopted plan. The final version of, or the final item that addresses your affordable housing obligation is a revised River Road redevelopment plan. The River Road redevelopment plan always had housing in it. The principal purpose of the document, which is dated May 2018, is to identify the 100% affordable housing project that is located within that redevelopment area. It proposes 88 family rental units. In addition, the plan has been revised to include a number of water-related and water-dependent uses as principal permitted uses that were not previously identified in the earlier draft of the redevelopment plan. So all in all, it's a plan designed to effectuate the housing plan element that you already adopted, but at reduced numbers.
Other than that, there's no other substantial changes in
Sure.
concept, conclusions that you
No additional sites, no changes.
And now, just so that everybody understands, there is a proposed resolution, assuming the board acts favorably on these issues, which are all intertwined and all associated with the soon-to-be-resolved declaratory judgment litigation that's pending before Judge Natale. So everybody should understand that the agreements associated with the resolution of that litigation are also part of this matter, and the resolutions to implement those agreements and the plans that we just referred to also implement all the agreements with the National Lead site and the K-Land site and the agreements. So much of this is also closely associated with the resolution of that litigation that the borough is obligated to conclude.
Correct.
And I believe the fairness hearing is at the end of the month?
28th.
What? 20th.
28th.
28th, sorry. So, you have anything else you want to provide for the record in this matter?
No, just to say that the housing plan element is a part of your master plan that you adopt. The other 3 items, the 2 ordinances and the redevelopment plan, are referral items for your review and recommendation.
There's actually a third ordinance. There's a 418-18.
Yep.
The 418-18 was,
Street,
a result of a misdesignation of the correct block number
Correct.
from 175 to 175.01. So the council rescinded the old resolution the old ordinance 415-18, adopted a new one, 418-18, which is also in front of you. That's the sole reason for that change. So having said all that and having concluded your remarks, Mr. Heyer, I guess we can open this up to the board if there's any questions, and then open up the public if they have any questions.
Are we gonna take this, one at a time? We take the fair share first?
The fair share is listed first. That's the big
Are there
document.
any questions on the fair share housing element, fair share?
Could you mention it again, I had it in here, but I can't find it now, the from 2 numbers, from Camelot 1 and Camelot 2, for both market rate and affordable, what it was reduced from,
Camelot 1 and 2 initially had in the March plan,
combined? Now, you give me combined numbers.
Combined.
Okay.
Camelot 1 is 173 market units, Camelot 2 was 300,
Right.
for a combined of 473 market units. The proposed plan has a total of 318 market units. Camelot 1 is at 168, Camelot 2 at 150, and the number of affordable units associated with both of those projects is being reduced from 71 units to 20 units.
Thank you.
Anybody else have any other questions under the housing element and fair share plan? This is the one that we have to adopt, so I need a motion.
Just for the record, we also want, Mr. Edwards, you want to stand up, sir? Mr. Edwards is also here. He's from the law offices of Jeff Serenian. He and I work closely together with respect to drafting the resolutions that are in front of you. And of course, Mr. Serenian's office is handling the current affordable housing litigation, which is primarily the reason why I think the number of units went from 785 to substantially less, which is in front of you this evening.
Thank you for that, and thank you all for having me tonight. The number of units that are the quota or the fair share didn't go down. What went down is, how you get to that number, because we were able to get you credits for things that you hadn't been claiming credits for, largely, including, Lakeview, which was a large prior cycle credits project, and Gillette Manor. Those were the 2 primary mechanisms for credits you guys really already had in the bank, and we're not getting the benefit of.
All right, thank you. I don't find the necessity to swear Mr. Edwards. Obviously, he's an attorney representing the borough.
That's it. Any other questions of Mr. Heyer? Gruhl?
Hire Gruel. Hire Gruel.
Heyer Gruhl,
It's all
the
the same.
attorney.
It's
So,
been so
I
long.
get it. I understand.
If not, I need a motion to
We gotta open up, it's up to the public.
open up to the public to discuss the fair share plan.
I'll make that motion.
Second, all in favor?
Aye.
Ma'am? Come and take the mic.
Fred, you could sit down and relax.
All right, but I may be asking you questions, and I may be asking Mr. Edward questions. I don't know if there's another mic, or if he can use something so he goes on the recordings you'll share with Mr. Edwards. I just wanted to...
Address the board,
Sorry.
ma'am.
Ma'am.
Sure, certainly. I'm Janice Benedetto, 1 Thomas Avenue in the Melrose section. I'm within 200 feet of the National Lead Cross Avenue property.
Ma'am, are you going to be just asking questions, or are you going to be providing any testimony or input? If you do, then I'm going to have to swear you in.
You could swear me in.
Yeah, let's do that. Let's
It
be
doesn't
safe.
hurt.
All right, you want to raise your right hand,
Sure.
please?
Let me just put my paperwork down so
Sure.
I can raise my right
Got a
hand.
testimony you're about to give the board in this matter as the truth, the whole truth, and nothing but the truth, so help you God?
So help me God, yes.
Thank you.
All right. Now, the first fair housing portion of this, When we saw it, we could not read the chart. The copies we got were very poor. So I just wanted you to review so everybody understands how much goes to each designation, because there was a big change, and I understand higher rules agency or consultants, municipal planners found credits for us. And there were changes in the River Road project from what was going to be market rate versus affordable. And I'm slightly confused on what my knowledge is of the national lead, because the way it was represented by Mr. Heyer, previously I had it as 164 total units, and 24 of them were going to be affordable. And now the new ordinance for the National Lead Cross Avenue property has them at 132 total units. 125 are going to be market, and 7 are going to be affordable. So there's some confusion in how you represented it as what is total, market, affordable, how the breakdown works. And then the other thing is, in that chart, as I'm understanding it, and I'd like somebody to verbalize it, since we don't have a copy of it here, and the copy we got at the council meeting on May 29th was unreadable, that the credits and the to-be-built units and existing units add up to 792. The court requirement is 785, so we have a surplus, to my understanding, of 7. So if you could just review that topic, I'd greatly appreciate it.
Well, hold on a second. So just as to the 2 inclusionary sites, it was a bit confusing, but you are correct. It was 164, or 163 and 24. Now it is 125 and 7 for a total of 132 on the NL site.
63 and 20.
163 and 24, 25. I can't remember. Yes. Yeah, a total. And then, so of the 163, 24, 25 are affordable. Now it's 132 total. Of those 132, 7 are affordable. And the same is true of the K-Land sites. It was 473 cumulatively. Then they had to set aside. Now it's cumulatively 318 new units, though there are 2 Corky units, and there are 20 affordable of the 318 new units. As to what changed on River Road, it went from an inclusionary project to way back. The last 2 iterations of the Housing Element Fair Share Plan you would have seen would have had 88 units at River Road. I don't have the chart in front of me, but I do recall there being a surplus. That was important because things can go wrong, weird things can happen as you proceed through compliance. So you're better off having a little bit of a buffer in the event that some of your credits don't come to fruition. As to the chart, and I apologize to the extent you weren't able to read it. I'm happy to let Fred walk you through the chart.
You have it correct. You have your numbers correct.
Question then. The chart had various locations, so I just would like you to run through for the public's benefit, because people do watch this on YouTube from the website and on Cablevision Channel 15, what that chart stated, since we don't have a copy of it.
Okay, just to go back through the numbers. The original draft of the plan, the March plan, had 163 total units on the NL site, of which 25 were affordable. The current draft has 132 units with 7 affordable. On the Camelot 1 site, the original plan had 173 total units, and the current plan has 168 total units. Camelot 2 had 300 units. Camelot 2 has been reduced to 150 total units. In both plans, in both sites, the combined number of affordable units was previously 71. It's now 20.
All right, thank you. Now, the rest of the chart leading up to the 792, because you found additional credits, things switched around. If you could go through with how we arrive at that 792 now.
Okay. The third round obligation is satisfied by a number of mechanisms. They include an existing age-restricted development known as Lakeview. There's 90 credits there. There were, in the age-restricted portion, Lakeview produced 100 credits of family rental units. The Parlin New Club boarding house, we had previously taken a credit. It's not in this version. We couldn't document that. Gillette Manor is an existing age-restricted rental project that had 84 credits. Chase Partners was an existing age-restricted rental project with 22 credits. Caring House 54 is a group home that counted for 4 units. The accessory apartment program took credit for 10 units. Luxury Point is a proposed inclusionary family rental project that was going to produce 170 units in both plans. And we talked about the NL site, the K-Land site, and the River Road redevelopment area. In addition to those credits, the borough is entitled to rental bonus credits. The affordable housing rules allow 2-for-1 credits for family rentals within certain limitations. So there are credits for 197 bonus credits. So it comes up to be 792, or 70 units less.
So there are 70 units less, actually affordable units less, that are covered with credits of either existing properties or the River Road project by Sarah is now 100%, 88 units going towards the affordable. So that accounts for the changes.
That's correct.
All right, so you found new credits, and there was a change in how the Sarah property was allocated with no market rate units in all affordable housing.
And we were able to reduce the density on the other sites, yes.
And we appreciate finding the additional credits, and we appreciate all of the density improvements that have occurred. And at some point in time, I assume that we'll be able to, through the Open Public Records Act, get a legible copy of that chart? All right, thank you. And in addition to what you were saying about resolutions and settlements, at the May 29th meeting, you had said the settlement agreements were changing prior to the meeting, very shortly before, and what have you. Are the settlement agreements now final?
Yes, they are final in the form that you will see tonight. And actually, there are 2 other agenda items. So Fred mentioned the 4. In addition to those, there are 2 resolutions authorizing the execution of those settlements, because at least the 2 settlements with respect to the developers, K-Land and NL. The planning board are signatories of those agreements. So they will be they are in final form now. Yes.
All right, and is that something that we can get a copy of this evening?
Logistically, I mean, you can get a copy of it once the planning board executes it. I don't know if logistically they have copies for you tonight or not.
All right, because we've been trying to ask for copies of the final, because you said they'd be available on Wednesday the 30th through the Open Public Records Act, and we haven't been able to get finals yet.
All right, can I just intervene?
Yeah.
Ma'am, did you make Oprah requests for those documents?
Yes, we did.
Then you should probably deal directly with the clerk in that regard, because I think they cost you money, right?
No, they
didn't
don't.
cost you any
They
money?
just email, and we do our own printing. They email a file, and we do our own printing, so there is no fee, and we've been getting documents for the whole past year.
Okay, good. Well, then that's the clerk's responsibility.
Okay, and does Terry Farbanak, the borough clerk, have copies or have files of the final settlements yet?
I'm sure she does.
Yes, she does.
If she does not, then I can give them to her.
Okay,
If she
that would be
If she
great.
tells me she does not have them, I will get them to her.
Okay, great. Thank you very much.
No problem.
Greatly appreciate it.
Thank you.
Anybody else? Ma'am? State your name and your address.
My name is Regina Lodato. I live at 20 Frazee Avenue in the Melrose section. I'd like to know,
I might have to swear you in.
why?
It's just a requirement. You swear the testimony you're about to give the board in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
I want to know, when you say affordable housing, I've been listening and listening and listening how we need this affordable housing. The national site in the Melrose section, they were supposed to give us 25 houses, and they're doing 4 bedrooms in each house. How come it's dropped down to 7 when we're going to be in the same boat not too long after today for affordable housing? It's constant. Every 10 years, you have to have a certain number of affordable housing. Why are we dropping down to 7? I don't know this gentleman. I don't know it.
That's Mr. Fred Heyer. He's responsible, his firm is responsible for doing the planning and investigation work with respect to the affordable housing obligation of the borough.
Thank you, Fred.
So, how you doing? My name is Mike Edwards. Once again, I'm the affordable housing attorney. So your obligation in any given round is to create a realistic opportunity for the construction of your quota, your fair share. In this instance, it's 785. So when we were hired, our marching orders were, well, we need to get density down on these projects. I do appreciate what you're saying. There's always a need for affordable housing, and of course, you'll be right back in the same boat in 2025 when you have to come up with a new plan again. But the marching orders we had from a negotiation standpoint were get the density down on the proposed inclusionary projects. So in order to do that, we had to, we initially hired an expert who told us what the market value would be if there were no affordable housing associated with the 2 projects. And from the developer's perspective, they already had a signed settlement in their hand, and they had ordinances that were adopted. So from a negotiation standpoint, really what we had to do to get the total density down was to bring the set-asides way down. And we were able to do that, largely by borrowing credits from other existing sites that you guys already have in town that you weren't otherwise getting credits for. So from that perspective, it was a question of what was important to the borough, and the borough wanted less density on the 2 inclusionary sites. So that's really the answer on why we reduced the set-aside and the density on the 2 sites.
Thank you for your answer. It's all according to the profits of what the builders are doing.
I don't know that I'd characterize it that way. I mean, at the end of the day, once again, you have a constitutional obligation. You're meeting that obligation, and there's either a subsidy coming from you guys, the taxpayers, typically, in some form or another, or the subsidies coming from, internal subsidies associated with the market rate units, otherwise known as inclusionary zoning or development. So, to fix the prices of the units, the money has to come from somewhere.
Thank you. Who's going to pay for the school that we're going to need?
That's not up for discussion, ma'am.
I'd like the attorney to know, I couldn't hear him in the beginning, and that's how come I didn't know who this gentleman was.
Okay.
I know it's hard to talk into the microphone.
Yeah, I had to put it on top of my book here.
Thank you very much.
Okay.
Thank you. Next, ma'am, white shirt. Name and
Margaret
address.
Carroll, 159 Oak Street, in the Melrose section.
Now, could you
I
raise
just-
your right hand, please? I have to swear you in. Swear the testimony about to give the board in this matter is the truth, the whole truth, and nothing but the truth, so help you God.
Yes. Okay, my question is, it says in this thing that they're going to have containers. Now, we're not going to be able to see them from Oak Street for their trash? And are they townhouses, or are they single-family homes? Because in the front of this, it says, single-family attached structures, townhomes. Which is it going to be? Townhomes or single-family homes?
What?
Single-family attached refers to townhomes.
So there could be like 6 of them together?
Correct.
Okay. Is it for sale or rent, or either or? If, just to say, just for an example, if I wanted to buy one and rent it, can I do that? Or is it just
Which site are you
either
referring
own it-
to?
National Lead? You're referring to the National Lead site?
Yes.
You want to know if you can buy one of the units and then again and rent it out?
Can someone buy it and then rent it?
Under the municipal land use law, you can't control tenure. You can't discriminate it. If someone wants to re-rent a unit, it's just like buying a single-family fee simple home. If I want to rent that home out to someone, I can. You can't control that.
Okay. And the containers won't be seen from our side of the street?
Well,
It's a planning issue when they come
Site
before us.
plan.
When they come before us, all of that will be done after that site is developed. That's when they have to come back for the planning board, and they have to go through all the engineering and the site reviews and things like that. And we take that into consideration.
Okay, so I could open my front door and find a dumpster in front of my house.
We would try not to.
We don't have
hope
that
so.
plan, the board doesn't have that plan in front of them yet.
So there's no idea until it gets put
No,
up?
we wouldn't be able to answer that question right now. It's
Okay.
kind of premature, but when the plan comes to us, whatever the subdivision plan is or site plan, that has to be on the plans, and we'll deal with it then you can come to the hearing.
Again?
Yes.
Okay.
When we do the site plan, when we get
And you
the
can't tell on that, on the picture that we had?
But we don't have the site plan in front of us because it's just, somebody has to develop it and come before us.
I understand that, but they're saying it's gonna be 100 feet from from Oak Street. So 100 feet could be the dumpster is gonna be on opposite of my house. And that's what I don't want. I don't care, you can build whatever you want, but I don't want a
Wanna look at the
dumpster in front of
dumpster.
my house.
And usually what we make them do is
I mean,
put
I can't leave a
berms
car
or
parked in
fences.
my driveway because the construction guy comes around and tells me I'm gonna get a $1,000 fine if the car's not registered and insured, sitting in my driveway. But yet you can put a dumpster out there. Makes no sense.
Well, like I said, that will be addressed when the plan comes in front of us, and you can certainly have your voice heard then.
Sir, with the blue striped shirt?
159 Oak Street.
Thank you, ma'am. Sir, you want to raise your
Charlie
right
Lukey,
hand? Sir, could you raise your right
324
hand for
Oak
me,
Street,
please?
South Amboy, New Jersey, Melrose section.
Could you say it again? She didn't get that.
It's my fault.
Charles Lukey, 324 Oak Street, Melrose section of Saraville.
Mr. Lukai, go ahead. You want to?
All right.
Can
Can you
wanna
just raise
swear
your
me
right
in?
hand, sir? Thank you. You swear the testimony you're about to give the board in the matter is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir.
Okay. My number one question, who on the board said that the National Ledge site is an ideal place to build? I got an answer? No. Okay. You people, you did your planning, right? You know there's no sewers over there. How you gonna get the effluent from down there in that hole down to this treatment plant? Who's gonna pay for the sewers? And if you do try to do it down Oak Street or whatever street, how many check valves are you gonna put in? Everybody on the lower part of that deal gets a check valve? Or do we wait for the cellars to fill up with effluent? What's going on? Give me an answer.
We don't have a plan in front of us about any of that, so
You don't have a plan
No.
for it, but you want to take and turn around and give these people, right, the authority to build.
well, it's not.
How can you take and turn around and tell somebody that they can build without a plan?
Because they have a right to do
Do
it.
you build a house from the roof down?
But sir, the court gave them, NL filed as an intervener and won their court case. Wasn't our choosing for that site. NL filed as an intervener, they won their court case. The court gave them the right to build there.
Mr.
From that
Right.
point, we're negotiating those numbers down.
Okay,
which
Pat.
is what
Mr.
the
Lukai,
attorneys
all of
The
did.
the court gave them the right to build.
Yes.
Did you tell them that it's not feasible?
Wait,
Did you
wait,
tell them how much
Wait a
money
minute.
it's gonna cost the
Sir,
taxpayers of the town for you people to give them a favor?
Sir, this is an engineering thing, and you're not an engineer and I'm not an engineer. But before they come before us, they have to do the site plan, they have to do all the engineering and answer all the questions that you're answering. All they have now is the permission to do what they want. They have to come before us with a complete set of drawings explaining how they're gonna do it before we would agree to it,
Exactly.
okay?
It don't make sense, Tom.
Well,
It don't make sense that
but
you're gonna
it's-
give
it's
these
the
people.
It's the process that we have to. I think of all of the sites that we're talking about tonight, that is the most unfeasible place to build, okay? It's gonna cost a lot of money to do it. But, being 23 miles away from New York City, someday it may be worth it. But that
Who's gonna
doesn't
pay
mean-
for it? Me
Developer.
and the rest of the neighbors?
No, you don't pay for it.
Developer pays
Yeah.
for it.
In your taxes, you do.
The developer would have to put in the infrastructure.
The developer is gonna be responsible for running a sewer line down to Route 4.
Wherever.
That's an idea that we don't have any clue about right now.
Because if he hooks up into the existing sewer lines with that amount that you got on top of the hill, you're gonna take and turn around and backfill just about everybody's cellar down on the lower end of Melrose.
Well, I guess the appropriate time for you to proffer those comments is when that plan comes in front of us.
Well, I'd appreciate you people consider this and think about it a little better, because the way things are going here, you're gonna give them the approval, the okay to build. And guess what they're gonna say? Well, we built top of the hill, that's where the pipe ends, you figure out the rest.
That won't happen.
That's not gonna happen.
That's not gonna happen.
That's not gonna happen.
Put it in writing.
Okay, when the plan comes to us, we'll be able to do that.
Put it in writing. Put it in writing.
We have the borough has engineers, the borough has planners, we'll make sure
Okay.
that
All
those
right.
things are protected.
Yep. Just remember, you're gonna have to wind up putting check valves in everybody's damn house in Melrose. Have a good day. Thank you.
You're welcome. Ma'am with the red shirt, the striped shirt? As a plumber, I don't mind putting check valves in. Good evening.
Good evening. Ruth Ann Mahoney, 2 Gerard Place in Parlin.
Hi,
Ms. Mahoney, could you raise your right hand? Thank you. Do you swear testimony you're about to give the board in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
I just want to say this plan, this new plan, is so much better than the original and any others up until this time. I do appreciate all the work that these gentlemen and ladies have done and all the work the town has done. But from my point of view, and I live off of North Ernston, and for the town, this is so much better and makes so much more sense. So I really hope you all do consider this plan. Thank you.
Thank you.
Thank you. Okay. Then,
Anybody else from the public?
nope.
Anybody else from the public? If not, we'll close the public. Need a motion?
I have another question with Mr. Heyer before we vote.
Let's
we
close the public and then we'll do.
Go ahead.
Could I ask one question
See?
before you close the public?
Yes, ma'am.
Janice Benedetto, 1 Thomas. I don't want to speak inappropriately at the wrong time. Is this portion just for the first fair housing
Yeah.
settlement? And I'll get to ask further questions when it gets to the ordinances individually.
Well,
'Cause there's-
they're part and parcel of all of what we're talking about. There's nothing else that's going to change from what you already heard.
All right, so that this is all inclusive to talk about any aspect of any ordinance.
Right, because of the ordinances all implement the affordable housing obligation of the borough. And and the agreements that are made pursuant to, don't forget, we're still in court on that.
Right, and I understand that. Well, then I'll not withhold the other questions I had then. I was just taking it step by step because there were 3 separate settlement agreements. There was the one with the Fair Housing Center, there was the one with K-Land, and there was the one with National Lead.
Okay?
All right, so regarding the one with National Lead and the concept plan that was attached to the ordinance at the May 29th meeting, when we went to the council meeting on Monday, June 11th, they said that you had an answer now as to whether the townhomes are for sale or for rent on that concept plan. When I had asked the question at the May 29th meeting, Ms. Gruhl had said they didn't know the answer to that at that point. But now at Monday's meeting, Councilwoman Kilpatrick said that you'd have that information tonight.
It's my understanding that the affordables will remain rental and that the residual, the market rate units will be for sale townhomes, correct?
That's what they proposed.
All right, and let me ask you this. If that's what they're proposing now, do they get the option of changing that later and making substantial changes to that concept plan?
Well, so the concept plan is a little bit less developed, let's say, than the ordinance at this juncture. So, you know, they provided this concept plan for more of illustrative purposes. They were reluctant to agree to anything like substantial compliance given the late hour, though, you know, I think generally this is what the concept plan will look like. As to the ordinance, I don't think the ordinance does or can specify the tenure of the market rate units. So, you know, at this juncture, it's envisioned that they'll be for sale, but under the terms of the ordinance, they could theoretically switch that, though it's going to be townhomes, so it's unlikely.
All right, so there's still a lot of leeway. There's a substantial difference in this ordinance for the National Lead property than the original ordinance that was produced in 2017 around May 22nd, that the public hearing was on June 26th of 17, and then it's also substantially different than the court-ordered one in a lot of ways. And National Lead is not in the business of building houses. It has a lot of particulars in it that seem like the developer was very involved in the ordinance. It deals with signage, and there's been a change now in trees and things of that sort.
Right, yeah, so the initial ordinances that you were looking at, the court-ordered one and any prior iteration, before the court-ordered one, none of those would have been produced by your new experts, Hire Gruhl and Associates. So this is something that was their template, as opposed to working off NL's template or whoever developed the prior iterations.
So whose template was this ordinance? I missed it. Sorry,
Your
I
experts,
apologize.
Hire Gruhl and Associates.
Okay, that's who.
The new NL.
The new NL was more or less drafted by Hire Gruhl.
Yes, and then there were particular, you know, components that we negotiated like anything else. They said we can't live with this. You know, we said you can't change that. There's wiggle room here. There's not here, and you know, it's a negotiation like anything else.
I understand that. Now, there's a few points of the settlement agreement for National Lead that we received at the May 29th meeting that I question. For instance, it seems like all the rights go with the land, and if anything changes, it's all in the developer's favor or National Lead's favor. We did manage as residents to accomplish some things. For instance, the Open Space Committee in September of 2017 recommended that the National Lead property and the 4 acres of K-land be purchased for open space. Now, I understand the negotiation for Kaplan went very well, and I'm very, very happy that those 4 acres are going to be hopefully completed as open space purchasing. But for the National Lead property, I understand what made it so difficult was that the contractor or developer involved, Bob K, PRC, Rockville LLC, whatever you want to call it, was really playing hardball and wouldn't cooperate as well as K-Land did. Now, I don't understand why, in case for some reason that developer backs out, we couldn't possibly negotiate a clause that the borough would have first right of refusal on purchasing the land for open space if we were willing to pay. We got comparison to appraisals if we were willing to pay what the developer was paying for the property. I understand they have an existing for sale purchase contract right now, but in case anything changes, I would hope that we would have first right of refusal and that the rights and wouldn't just go with the land, that maybe we would still have an opportunity to purchase it for open space, should their deal fall through.
Okay, so a couple things, and I'll try to remember all of your questions. But you know, the first thing is you have an obligation to create a realistic opportunity, right? So to the extent you have contingencies in your agreements that would permit you to back out of the zoning entirely, you're not creating a realistic opportunity in theory. The second thing is, I mean, they had developers' rights, right? The developer's not going to want to say, oh, you know, I want the equivalent ordinance, but I want this right of first refusal, here you go. As to, you know, our attempts to purchase it as open space and the developers' you know, reluctance to kind of play ball, we did try very hard to have, you know, to give them the same contract purchase price, them being NL. or around the same contract purchase price as the developer's contingency contract. The developer did not want to step out of the way on that. They have an interest in doing this, and NL unfortunately has an obligation to deal with them in good faith and fair dealing. So that ended up being a dead end. As to contingencies, right of first refusals, it simply wasn't something that was negotiated. And in this context, it'd be very unusual to have that type of contingency when you're relying on the site to produce affordable housing, regardless of who the developer ends up ultimately being.
Well, it also seems like at the end then that maybe it wasn't an issue of affordable housing because it sounded like they really wanted to do the 125 market rate units, and you had to really negotiate them to put the 7 in and what have you. That they, how can I put it? They achieved through errors in credits and errors in making a plan originally, higher density, and they came down really not very significantly.
Yeah, so just to be clear, I mean, our experts said that the market equivalent, in other words, they'd make the same rate of return on the 164 with the 24, 25 affordables. He said it was 113 units. So when we got them down to 125 and they refused to go down a unit less, we said, well, then we need to get something. We need affordable units out of it. So the trade-off was instead of doing 113 with nothing, we had 125 and 7. The other thing, that I should mention is Fair Share Housing Center, the other entity involved in all these negotiations, had routinely said we're not going to settle on just market rate. So the market rate, concept was always just that. It was a concept, so we knew where our starting point was for negotiations. So it was really it was never really envisioned in my mind that we'd end up with no affordable on either of the two sites.
All right, and I understand affordable is necessary.
Excuse me, ma'am.
Yeah.
This is a very nice conversation, but I think it doesn't really belong here, and that's when you started your comment. These kinds of discussions, first of all, walk the line insofar as the borough's position in the litigation, number one. So we don't want to sit here and disclose our negotiation strategy on how we dealt with ultimately arriving at the settlement agreements.
Actually, we're continuing a conversation we had at the council meeting,
well,
answering the same.
That's where it belongs.
This isn't the council
That's
meeting.
where it
That's where it
belongs. Is what I'm saying. It doesn't really belong here. That's the governing body's province. The reason these ordinances come to the planning board is for recommendation as to consistency with the master plan, which has been amended this evening. We don't get into those particulars. We don't have the power or jurisdiction to entertain them.
All right, so what is the purpose of what you're here to accomplish tonight then?
Well, there's a public hearing on the proposed amendments to the master plan by virtue of the agreements, the fair share, the housing element fair share plan, number one. That's a public hearing, which has already been discussed. The ordinances and the settlement agreements are already part of the record. We're here just to implement them. And the way to implement those agreements is by the ordinances that are in front of the board tonight. We look at those ordinances for our perspective, and our function under the municipal land use law is to look at them and make sure that they're consistent with our master plan, which they are. I assume they'll conclude that. And we give a recommendation to the governing body. That's what our function is.
And they make the decision.
The ultimate decision comes from the governing body, and that's where the comments that you are making now really belong.
All right, I understand that. So then I will say that we're in this position right now from a master plan being developed and errors being made in calculating credits and things of that sort. And it's a pity that 22 acres, which we don't have another area in this town that large of woodland and wildlife, is going to be destroyed. And I just hope in all good conscience that the planning board and the council, the mayor, all our elected officials, all our appointed officials, all our hired professionals work on all of these sites that we're talking about tonight and future sites in best benefit of the environment, the residents, and do the best job possible in all good conscience to become knowledgeable and informed, so we eliminate mistakes and errors that cost the taxpayers legal fees, tax dollars, that are going to destroy trees, wildlife, and cause deer and wild turkeys to get killed on the Parkway and Route 9 now, and to destroy the quality of life in the borough. So as site plans are presented before the council and future developments are presented, but not only the council, I mean the planning board and whatever zoning boards, whatever the proper procedures are, that it's looked upon with all the care and attention you would give the finite details of your own lives, so that the public is properly notified at the proper time, because we understand that part of the settlement process of motions and briefs and arguments was that the public was not properly notified at the proper time, that we get involved more in that there's more notification and different ways of, and that we're notified at the proper times, because certain things that we have done have improved this. I mean, at least we're buying 4 acres, God willing, of open space to be added to Kennedy Park.
You would be
So-
entitled to all the statutory notices, and the board follows the municipal land use law to the letter. So whatever plan comes in front of us, you will be duly notified. It'll be duly published in the newspaper. If you're within 200 feet, you're going to get a letter.
I hope things are really considered when it comes time to implement ordinances such as I understand there's like a reforestation, a tree bank ordinance, and things of that sort. And if the building takes place at the National Lead Cross Avenue site, that a traffic study is carried out, because a traffic light at the bottom of Cross Avenue and Raritan Street will be greatly needed, and things of that sort. So I appreciate your due diligence and all of your efforts and hard work to make sure that if we can't reduce the density or make any further changes to improve it, that we build the best developments possible to keep the quality of life in this borough, so that we don't destroy our beautiful town. Thank you.
You're welcome. Anybody else have any comments? Seeing none, I'll take a motion to close the public.
Second.
All in favor?
Aye.
What's your pleasure?
I just had one question for Mr. Hyatt before we
Go
vote.
ahead.
Sir, can you explain why we didn't take 100% credit for Gillette Manor? What is there a cap on,
There's a cap on age restricted.
what is that cap?
It's 25% of your total obligation.
Okay, and how many, what did we take, 84 units that we got credit for, you said?
It would be 25% of your 785 third-round obligation.
Oh, collectively, okay.
Collectively, for all the
You're
seniors.
maxed out.
And the reason for that is?
The fair housing rules try to encourage additional family housing, and the thought was that senior housing doesn't meet the real need. So there was a cap, because senior was too easy to do. Everyone was doing seniors.
Monroe.
So there was a push toward doing more family housing.
Since I've been up here, that's all I've heard is the need for senior housing, so. Very good, thank you.
All right, we have the amended housing element plan and fair share. What's your,
Mr. Chairman, to make a motion that we approve and accept the fair share plan as presented us this evening.
I'll second that.
have a roll call?
Mr. Hurtkevich?
Yes.
Mr. Davis?
Yes.
Ms. Lee?
Yes.
Councilman Lembo?
Yes.
Mr. McEnroe?
Yes.
Ms. O'Leary?
Yes.
Mr. Voloshin?
Yes.
Chairman Ty.
I'd like to thank all the professionals for all their help for getting us through all of this. These reports are quite lengthy. They were great reading before I went to sleep. Very good professional job, and that's a yes.
Then we need to adopt the proposed resolution to memorialize what you just did.
And we have a resolution here
Yes, you
before
do.
us. The resolution of the Planning Board of the Borough of Saraville, Middlesex County, New Jersey, adopting the amended housing element plan and fair share. Do I have a motion to adopt this?
I'll make that motion.
Do I have a second?
Second.
All in favor? Roll call?
Mr. Herkevich?
Yes.
Mr. Davis?
Everything else.
Ms. Lee?
Yes.
Councilman Lembo?
Yes.
Mr. McEnon?
Yes.
Ms. O'Leary?
Yes.
Mr. Voloshin?
Yes.
Chairman Ty?
Yes.
Resolution approved.
All right, so just for the record, Mr. Chairman, the remaining documents that we've already alluded to, and Mr. Heyer alluded to, and Council, Mr. Edwards alluded to, also need to be adopted. There are draft resolutions to adopt the amendments to the ordinance that you have. There are two resolutions to authorize the chairman to sign off on the agreements with NL and K-Land. Final resolution is the River Road redevelopment plan amendment, which you also heard Mr. Heyer testify about, as well as the ordinance 418-18 that implements that amendment. So we could take one at a time. Anybody has any questions about them, we can answer them. If not, the record has covered all of those documents. And we can proceed after that.
So we're gonna take the ordinance 413-18, ordinance of the Borough of Saraville amending the supplement Article 3 of Chapter 26, Land Development of the Code of Borough of Saraville, establishing a new affordable house district, A1, AH1 and AH2, and to set forth the standard and criteria for applicable thereto. That's the Kaplan 1 and 2. Do I have a motion to pass that ordinance on to the Borough Council?
I'll make that motion.
Do I have a second?
Second.
Roll call?
Mr. Herkevich?
Yes.
Mr. Davis?
Yes.
Ms. Lee?
Yes.
Councilman Lembo?
Yes.
Mr. McEnon?
Yes.
Ms. O'Leary?
Yes.
Mr. Voloshin?
Yes.
Chairman Ty?
Yes. All right, next one we're gonna take is ordinance 414-18, ordinance of the Borough of Saraville amending to supplement Article 3 of the Chapter 26 Land Development of the Code of Borough of Saraville to establish a new affordable housing district, AH3, to set forth the standards and criteria applicable thereto. Need a motion for that?
I'll make that motion.
I have a second.
Second.
Roll call?
Mr. Herkevich?
Yes.
Mr. Davis?
Yes.
Ms. Lee?
Yes.
Councilman Lembo?
Yes.
Mr. McEnon?
Yes.
Ms. O'Leary?
Yes.
Mr. Voloshin?
Yes.
Chairman Ty?
Yes.
You want to do the two agreements associated with that?
Yes.
Let's do the two agreements, because that keeps us consistent.
We have a resolution of the Planning Board of the Saraville, New Jersey, the County of Middlesex, State of New Jersey, authorizing the execution of the settlement agreement between the Borough and the NL National Industries. Do I have a motion for that?
So moved, Chairman.
Second?
Second.
All in favor? Roll call?
Roll call.
Yeah.
Mr. Herkevich?
Yes.
Mr. Davis?
Yes.
Ms. Lee?
Yes.
Councilman Lembo?
Yes.
Mr. McEnon?
Yes.
Ms. O'Leary?
Yes.
Mr. Voloshin?
Yes.
Chairman Ty?
Yes. All right, we have a resolution before us from the Planning Board of the Borough of Saraville, the County of Middlesex, State of New Jersey, authorizing the execution of the settlement agreement between the Borough and K-Land Corp. And that's for all of the K-Land properties, right?
Correct.
All right.
So
I need a
moved,
motion
Chairman.
for that.
So moved, Chairman.
Second?
Second.
Mr. Herkevich?
Yes.
Mr. Davis?
Yes.
Ms. Lee?
Yes.
Councilman Lembo?
Yes.
Mr. McEnone?
Yes.
This is the last.
Ms. O'Leary?
Yes.
Mr. Voloshin?
Yes.
Chairman Ty?
Yes. And the last one?
Yeah.
And this is the last one. Ordinance 41818, ordinance to adopt the River Road redevelopment plan as amended.
Okay, so that's to consider the amendment to the River Road redevelopment plan and the ordinance 418-18 implementing it.
Right. I need a motion to implement it and for the ordinance.
I'll make that motion, Chairman.
Do I have a second?
Second.
Mr. Herkevich?
Yes.
Mr. Davis?
Yes.
Ms. Lee?
Yes.
Councilman Limbo?
Yes.
Mr. McEnone?
Yes.
Ms. O'Leary?
Yes.
Mr. Voloshin?
Yes.
Ms. Matilla? Oh, Chairman Ty?
Yes.
Application approved.
That's everything?
Mm-hmm.
Did I forget anything?
I think we have it all.
We did 5 of them.
Good?
Just want to double check, I don't miss anything.
You got it
3, 4, 5, 5.
Got everything.
That's
Okay.
correct.
all. Memorialization resolutions? None? We did that, right? Public portion? Anybody like to speak before us? If not, ma'am, go ahead.
Ruth Ann Mahoney, 2 Gerard Place, Portland. Thank you all. This has been a better night than other nights. So thank you. Appreciate it.
You know, we don't get many compliments. Thank you very much. Thank
Take
you.
it.
I need a motion to adjourn.
I'll make that motion.
Can I get a second?
Second.
First of all, I'd like to thank all the professionals, and I'd like to definitely thank the board for this heavy lift. Thank you very much, and good night.
Thank you, guys.
Great job.
Yeah.
I got a bad shoulder, I gotta reach down there and pick that up.
I want to hear about this.
Mike, I